All right, welcome to our Law of Trusts Q&A slash revision session. I see I've opened it up here, and it seems to be working. So the way it works in terms of the questions is some of you have sent in questions, and then those are the ones we're going to obviously look at as well because, well, I already have them. And then you can also ask questions in that little window where it says say something right next to the video on YouTube. So entirely up to you which uh, if you want to ask questions, very easy to do that. And obviously, as I said, some of you have already sent in some questions. So what we're going to do is we're going to go through the topics just one by one. And I'm not going to make it sort of a big revision. I mean, you have we really had some summation kind of lecture. We had uh, all the tutorials and lectures and everything that you have your worksheets, so you have all the details that you need there. So what we're really going to go through is more sort of a skeleton like just okay, this topic, just remind ourselves what are the main points to remember about this, and then you just ask me as we go along. You just ask me whatever you want to ask about the particular topic that we happen to be talking about. Before we dive into it, just a few words on the exam itself. We've said this many times. It's also in the course outline. So the exam is going to be a 2-hour exam. You have 4 questions that you're going to be presented with, and you only have to answer 2 of them, and you can answer any 2 you want to. So there's no compulsory questions. You can just do whatever you want to. 3 of those questions are going to be essay questions, and 1 of those questions is going to be a problem question. So the problem question is going to be sort of the same format that we've practiced a few times now in tutorials, as well as I recorded a video on one of the previous exams just in terms of going through the problem question, how I would do that. Now the topic of those videos in relation to the previous exam. So this is something I had initially done because we were going to discuss it in the tutorials, and I just wanted to have everyone to have the benefit of that, so that you can find those. Those are not on YouTube because that's very specific just for us here. In fact, it was very specific for my tutorial groups, but it is on my e-learning. So if you want to have a look at those videos, you can get them on my e-learning. And basically what it does is it just discusses the previous exam questions from, I think it was from last year. It just goes 1, 2, 3, 4, goes through every question and just sort of how I would have done it. Now, when I say how I would have done it, doesn't mean that this is how you have to do it, and you know how this works. So it's really just it's suggestive in a way of how you could do it. But as I've said many times, there are many different ways to skin a cat. There's many different ways from getting to 0 points to 0 marks to 50 marks, which is obviously the maximum for each question. And sometimes students talk about things which I hadn't even thought of or I hadn't anticipated. And if it's relevant, and if it's good, and if it's relevant cases and relevant discussion, you get your marks for it. So there's different ways of getting there. So just an example of how you get there would be in those videos, which are on my e-learning in relation to the past exam. And I've posted 2 past exams online, so you can have a look at the one before as well. I think the 2016 was the one I discussed. 2015 is also online, so you can have a look at that as well. I'm not going to discuss that as well. That one you just try on your own, and then you use all the different materials you have available to sort of gauge where you're going with that. All right. What we're going to do then is we're going to jump right into it and discuss the various topics that we had on this course. And as I said, I've got a number of questions that have already been put forward, and I will discuss those as we get to those topics. And you are very welcome through the discussion tool on the YouTube channel, where you see there's my name with a little crown, and it says say something. So that's where you type in whatever your question is. First topic then, how did we start this all off 11, 12 weeks ago? We started off with something called the Three Certainties. Now, what is the Three Certainties? Well, the Three Certainties is the first of 4 things we check for when we try and find out whether there even is a trust. So remember, the course was basically divided into two halves. The first half of the course, the first 5 or so weeks, were spent just doing, is there a trust? And so we have to answer 4 questions, or we have to check 4 things. And the Three Certainties is the first of those 4. And then the remainder of the second half of the course was spent doing specific kinds of trusts. Okay. So the first of those 4 things is called Three Certainties. Certainty of intention, certainty of subject matter, certainty of objects. The idea behind that was very simple: to gauge whether the trust is certain enough. By certain enough, we mean, is it clear that whoever it is that oh, sorry, we got a question here about let me just answer that very quickly. This someone wants to know what this is about, so let me just type the answer just in case someone comes late or whatever. So what is this live stream about? This stream is about preparing students for an upcoming exam. There you go. All right, sorry about that. So Three Certainties. Three Certainties basically tests whether the trust is certain enough. What do we mean by certain enough? Well, if you're going to set up a trust, we want to be sure that that's actually what you intended to do. Because it would be a shame, wouldn't it, if someone says, well, you set up a trust, but you didn't actually, that's not actually what you wanted to do. And then it's a trust, and then, your property is with someone else, and it has all kinds of consequences. So that's the first one, certainty of intention. Did you actually want to set up a trust? And you can always think of Paul and Constance. This is a case we can always come back to in so many different ways. Paul and Constance is there to test whether or not Mr. Constance had the intention. It's one of the things the court case tells us, whether Mr. Constance had the intention of setting up a trust, and there was some evidence that he did. For instance, he had set up he had gone to the bank and tried to open a bank account for both himself and Miss Paul, the girlfriend, and the bank said, well, because you're not married, we can't do that. But through that discussion with the bank, it became clear that Mr. Constance wanted to share that money that he was going to put in the bank account between himself and Miss Paul. So that evidence, along with the words he uttered, which was he uttered the words to Miss Paul, I think it was at the bank in front of the people there, this money is as much yours as mine. All of that meant is he wanted to share the money with her. In other words, half of it was going to be hers, half was going to be his. But because the bank didn't allow them to have a joint account, all the money was in his name, because the account was just in his name, not in Miss Paul's name. So then, what sort of legal instrument do we use to make that money partly Miss Paul's, because of the intention to share it? Well, that's when the trust comes in. So we use the trust as the legal instrument to try and bring in the trust, so that Mrs. Paul gets some legal title to that money. And so the way we do that is by saying Mr. Constance wanted that money, even though it's in his own name, because the bank account has his name. So even though it's in his own name, Mr. Constance wanted it to be half Miss Paul's, and the way Miss Paul gets it is by way of a trust. So the money is in the account. Legally, it's Mr. Constance's money, but half of it is held on trust for Miss Paul. So certainty of intention. We also have certainty of subject matter. That means, is it certain what the subject matter is? So what's the subject matter? Subject matter is the property itself. So if you're going to say, I leave my house to so-and-so to be held on trust for someone else. Well, if you have only one house, then it's clear that that is the subject matter. If you have 2 houses and you say, I leave my house, well, that could be any house. So it doesn't really work that way if you're not clear. And the third one, certainty of objects, again, you have to be very clear who the objects are. The objects would be the beneficiary, so who gets the stuff. So in the olden days, it was very simple. It would just be I leave this on trust for my niece or my child or whoever, for Mary, for John, whoever. And that's clear then, we all know who the beneficiaries are, certainty of objects. Then, and this is now we get to our first questions. Question that I received is, how does it work when the when the object is not named? Okay, so it doesn't say I'm leaving this house on trust for Oliver or for John or for Mary or whatever. What if what if it says this, I'm leaving this house for family or employees? So we had a number of these cases. So is it allowable to have the objects as groups, not specifically defined by their names, but defined as groups, family, employees? Those were the sort of cases we came across, and the answer is it is allowable. Okay, so that was because there is still sufficient certainty there to allow that. But, and this is where we get to McPhail and previously Gulbenkian. You got to think of it this way. So if it says I leave this, I'm setting up this trust for my employees, and you got to wonder, okay, the employees is a group. Can we identify each of them? And you'd have to say, well, you know, even for a very big company, it is possible to identify every single employee. That's possible. But that would then be Gulbenkian. That would be the list test. So is it possible that the trustees are able to draw up a list, hence list test, a list of all the different beneficiaries, and then the trust is valid? But what if, and then we get to McPhail, and this is the question I received from one of you, just to kind of jump into that and just cover that in some detail, and I'm obviously very happy to do that. What if, like what happened in McPhail, let's read. Let me read what the instructions were in McPhail. The trustees shall apply the net income of the fund in making at their absolute discretion grants to or for the benefit of any of the officers and employees or ex-officers or ex-employees of the company, or to any relatives or dependents in any such persons in any such amounts at such times and on such conditions as they think fit. So now we're not only talking about employees, which, you know, you just go to HR and get a list of employees. So that's just a list. Now we're talking about employees. We're also talking about ex-employees. We're talking about officers. We're talking about ex-officers. We're talking about the relatives of all of those people, as well as the dependents of all of those people. So now we have potentially a huge group of people, and many of them, we're not going to be, if I'm the trustee, I'm not going to be able to draw up a list of them. How do I know about some dependent of some ex-employee? I mean, that's very difficult to sort of, for me as a trustee, to go and find those people. So McPhail sort of altered that a bit. So McPhail said that is still certain enough. We still have certainty. But instead of applying the list test, we say we go about using something we call the is or is not test. So instead of the trustees drawing up a list, what the trustees do is basically the trustees, we ask, is it possible for the trustees to act as trustees, you know, sit in their offices and have people come forward. So people come forward and claim that they are beneficiaries under McPhail. And then the trustees would be able to say you are or you are not a member of this group. So you are or are not a beneficiary. If that is possible in every single case, based on the evidence we have, based on the instructions we have, which, remember, the instructions were they had to be employees, ex-employees, officers, ex-officers, and relatives and dependents of these people. So a lot of potential people, but yes, the court thought it was possible that if any one of that group came along, for the trustees to say yes you are, or yes you are, or no you're not a member of this group. So therefore this was deemed to be sufficiently certain in McPhail. Now we'll come back to this when we talk about Denley a bit later on, which is another question I received, but that's it first of all for McPhail. Let's then move on to there's four sort of special circumstances where it does not work. So when does it not work? Well, it does not work when we have administrative unworkability as well as ascertainability. So what we're talking about now is we have the three certainties, all of them are there, everything's fine in the three certainties way, but there are other problems that come along. And so if it's if the trust is administratively unworkable, or if there is lack of ascertainability, then the trust fails. So what do those mean? Well, administratively unworkable means, and you set up a trust for and the beneficiaries are the people of an entire region or an entire city or whatever. And as it turns out, even though you left a lot of money, every single person is entitled to receive, say, $1. Okay, then it's administratively unworkable to effect that trust, to give it effect by sending everyone $1, because you'd be spending more money on postage and stamps and envelopes and issuing checks and so on than what would be left over for the people. So it's administratively even though you have all the certainty, it's administratively unworkable. Ascertainability basically means that it has become impossible to ascertain particular people because perhaps they changed their name or whatever. In those circumstances, or perhaps they died and you might not know that. So in those circumstances, the trust would fail, even though you had the three certainties in place. The other one would be the other two would be conceptual uncertainties and evidential uncertainties, which are sort of related. If you have those two, the trust doesn't necessarily fail. The trust can still carry on. So conceptual uncertainties would be when we have it's not clear that, even though we sort of we had several cases. We had like sort of the beneficiaries would only be entitled if they were Jewish, for instance. We had a case on that, but you could think of any number of scenarios like that. So it might be, from a conceptual point of view, difficult to ascertain whether someone was Jewish or not, and in the event, in the case, it was stated in the trust instrument how that was supposed to be ascertained. Okay, so if it says, oh, refer to this rabbi, okay, then that kind of gives you the answer. But if it doesn't say that, then perhaps it's something we can conceptually never really get to. That would mean that for some people, the ones we can't conceptually make that determination, they would not be entitled, but the others might still be entitled, so the trust itself doesn't fail. Evidential uncertainty is a related concept, which is where we just might not have sufficient evidence to prove that someone is Jewish or whatever or someone is to get away from the religion. What if someone was an ex-employee because the files are too old, they've been destroyed, and we just can't prove it? Well, the trust would still go on for those that we can prove it for, but the beneficiaries where we had these evidential uncertainties may not be able to get whatever they would have normally gotten as beneficiaries. Okay, so that's three certainties. Then we had capacity and formality. So capacity was very simple. You just basically you shouldn't be a minor and you should have mental capacity. It's very, very simple. Formality, the third one, is a bit more difficult. Generally, you don't need formality to create a trust. And we already know that, for instance, from Paul and Constance again. Mr. Constance just created a trust. Just by standing in a bank and uttering a few words, you created a trust. You don't need formality in that sense. But because it was over money, it was over personality. But in some cases, you do need formality. So you need formality, for instance, when you create a trust over land. So if Mr. Constance hadn't shared the money, but instead had wanted to share half his apartment with Miss Paul, then he couldn't have just stood in the bank and said, oh, I want to share the apartment with you. Because if you create a trust over land, it requires some evidence in writing. Something has to be manifested in writing, and this is very important because although this is the general rule in relation to trusts, when we a bit further on, when we talk about, for instance, secret trusts, we don't have that element, and yet the courts accept the secret trust. So the secret trusts are exceptional with respect, for instance, to formality. The other point about formality was that what if you had a trust that already existed? And so let's say you are the beneficiary of a trust. So you get some sort of trust income or whatever as a result of being a beneficiary. That means you have an equitable interest in this trust. What if you want to get rid of that and give it to your niece or whoever? You just want to pass it on because you don't need the money or whatever. Well, you can do that, but the transfer has to be effected in writing. The actual transfer has to be in writing. So for land, you needed some evidence in writing. In transfer of an existing equitable interest, you had the actual transfer had to be done in writing. And in testamentary trusts, well, they have to conform to the rules of whatever the specific rules in any jurisdiction are on wills. So wills have to clearly state exactly what the testator wants and who they want to receive what, and so on and so forth. So by extension, for instance, thinking again ahead, secret trust, that would mean that normally a testamentary trust would have to say, I leave this on trust with so-and-so for so-and-so. But of course we know in secret trust that doesn't happen. So again, that's exceptional in relation to the formalities. And then we had the last one was constitution. So constitution is in a way fairly straightforward, because technically speaking, constitution means you pass the legal title to the trustee and you pass the equitable interest to the beneficiary. But in practice, we only check for the legal title when we look for constitution, because we know that the equitable interest has already passed to the beneficiary through the three certainties that we did earlier. So if you have certainty of intention, you pass the equitable interest to the trustee, to the beneficiary, as would happen in Mr. Constance passing the half the share of the money, the equitable interest in that, to Miss Paul by having the intention. So that's already covered under that heading. Or similarly, we just did formality. So if you create your, if you have some evidence in writing, you create the trust over land. So you pass the equitable interest from the donor or the testator, as whatever the case may be, to the beneficiary. And so, in other words, when we look at constitution, we're really only looking at passing the legal title. So what we're asking is, has the legal title passed from the donor to the trustee? All right. Let me just see the okay, our stream was down there for a moment, so okay, we're back on. All right, we know in terms of the legal title passing, the old rule used to be Milroy and Lord. So in order for the legal title to have passed from the donor, the settler who creates the trust, to the trustee, in order for that to happen, for it to be fully constituted, so you have a fully formed trust, everything has to be done. So the donor has to have fully transferred the legal title, and it must now be fully with the trustee. Then that was softened up a bit in Re Rose, where the court said, well, that's a bit strict, because what if the settler, the donor, does everything they should have done, and just because of someone else's mistake, or someone else being sort of a bit lazy or tardy or whatever, it hasn't been done yet, or it hasn't been completed yet. So Re Rose said, well, in those cases, for the purposes of trust law, we accept fully that the trust is fully constituted. So in other words, as soon as the settler has done everything that he or she could have done, then the trust is fully constituted in terms of the legal transfer of title. Then remember, that was sort of softened up a bit, and this relates to, there's actually I give you the answer to this in the past exam question discussion, which I posted online, where I talk about the Pennington case and the Choitram case, where these things were not done, but sort of, I suppose luckily for us, those cases have since been sort of brought back in line through cases like Kay and Zetel, where we are basically now back at Re Rose. So the test is, when you test for fully constituted, you ask, has the title passed to the trustee in a way where the donor, where the settler, has done everything that they could have done. That doesn't mean the trustee now fully has the title. So for instance, in Re Rose, the problem was that Mr. Rose was going to transfer his shares to Mrs. Rose, and because the company whose name the shares were in had to register Miss Rose, and they were just a bit, they just took a long time to do it. The question was, when was when did Miss Rose, when was the process complete on the Roses part? And the answer was the process was complete once the Roses had done everything they could have done, and once they basically handed over all the documents and everything to the company to register Miss Rose as the new owner. And it's not the Roses' fault that it took the company a long time to do that. So we're basically back to that now. That was really the first part of the course. So we had 1, 2, 3, 4, the 4 requirements, and well, you also did an essay on that. So I think you should be fairly comfortable with all that. Now we then move to the charitable trusts. So charitable trust is just a special form of a trust, is a special form of an express trust, and we know that there are these 4 charitable headings. Now the reason why charitable is different from what we've just done for the past half an hour or so is because amongst the 3 certainties, certainty of the objects, what we don't have, so certainty of who's the beneficiary, we don't have that in charitable, because we don't know, when we set up a charitable trust, we don't know who the beneficiaries are going to be. We're not going to be able to say this is for John or this is for Mary or whatever. It's for a purpose, the purpose being some kind of charitable purpose. So how do we kind of justify that? Well, in other words, how do we justify the fact that we are not conforming to the 3 certainties, the last of the 3 certainties? And the answer is because it's charitable. Because charitable is a good thing. So the courts will try and help it along and try and make it work. And but it's got to be, so you got to follow some rules, and the rules are basically the charitable purpose has to fall under one of the 4 headings: poverty, education, religion, and the other heads, the sort of the 4th, which is a non-exhaustive list. And so when you look at something as to whether it's charitable or not, what you do first of all is you determine, is it under one of those 4 heads? That's the first thing you do. And then the second thing you do is, once you have established it is under one of the 4 heads, you ask, is it also for the public benefit? So you got to test both things. Is it under one of the 4 heads, number 1? Number 2, is it for the public benefit? Now there's and the public benefit, for instance, if you look at education, so Oppenheim had set up a trust for the education of employees, and the court held, even though it falls under the heading of education, so it is a charitable purpose, because it's only for employees, it's not to the benefit of the public. So it failed. So it's failed as a charitable trust. Same with religion. Remember Gilmore and Coates. Setting up a charitable trust for nuns to go and pray in a convent or so, it was missing the public benefit element, because how is the public going to benefit from that? It's an interesting case. When you read it, some arguments were made that the nuns, by praying, would sort of create a benefit for the public, but that was sort of, I suppose, too abstract. So there has to be a tangible public benefit for this to work. The only exception is under the first heading, poverty, and that is basically, we have a case called Dingle and Turner. The main reason why that is the case is because in the courts, for a long time it sort of wasn't clear. The courts sort of looked at, does it fall under the heading of poverty? And then they moved on, does it have a public benefit? And then sort of over time it just became as if the two are the same, because you're really asking the same questions, you're really sort of checking the same thing. And so Dingle and Turner, for instance, made it very clear that once you have established a charitable trust for the elimination of poverty, or for the relief of poverty, it doesn't really matter who the recipients are, even if the recipients are only, say, employees of your company. The fact that you are relieving poverty is in and of itself a public benefit, even if that specific benefit, say money or whatever, is not available to every member of the public. The fact that you're helping some members of the public is good enough. So in other words, what we called it is, we said that the test for public benefit has been subsumed into the poverty test. So the two have sort of merged. So don't make the mistake of saying that there, for poverty you don't need to show that there is a public benefit. You do. It's just that in practical terms, the test for showing public benefit has been subsumed into the test for showing poverty. All right, let me just see if we had any questions on that you had sent in on charitable. No, but you had sent in, there was a question on charitable purpose trusts. So let's move on to those then. So what are non-charitable purpose trusts? So non-charitable purpose trusts are trusts where we, similarly like in charitable, we don't have specific beneficiaries. So it doesn't say this, I passed this house to X to be the trustee to hold for John or for Mary or whatever. It doesn't say that. In fact, there are no identifiable people because the beneficiaries are not people. The beneficiaries are basically purposes. Now, in the end, of course, there's going to be people who benefit, but in the way that the trust is set up, it's for a purpose. And generally, that's not allowable. Okay, Morris and Bishop of Durham, beneficiaries principle, you got to have beneficiaries. Now, we said under charitable, it became allowable, but just because the courts sort of thought it would be a good idea to make it allowable, not because of any other reason. There's no other reason why we should breach the third of the three certainties other than it being charitable. So that doesn't apply when it's non-charitable, because non-charitable is not for the public, it's for something else. So why would it then be allowed? Well, the answer is generally it's not allowed. Okay, so generally non-charitable purpose trusts are not allowed. Now, in two circumstances, the courts have upheld them, and it sort of is logical. Those are the first of a list, and they are animals and monuments and graves. So if you want your pet to be taken care of, say after you die, you can set up a trust for that to be done. And that makes sense to do it that way, because how else are you going to solve that? So obviously a pet is not a person, so it's not a beneficiary under the three certainties. It's for a purpose, but it's allowable. The other one was monuments and graves. So if you set up a trust to take care of, say, your grave after you die, again, how else could you arrange that? Let's say if you didn't have family, if you didn't have anyone that you trusted otherwise, so you set up a trust for that to be done. So that's for a purpose, the purpose being to the upkeep and cleaning and maintenance of your grave. So those two are real exceptions in the sense that they are real non-charitable purpose trusts which are allowable. But then we had the other three: masses, private masses, as well as fox hunting, and then the last one, unincorporated associations, which is what one of your questions was about. So when we talk about masses and fox hunting, they're sort of exceptional in a sense, but in the end, if you read the associated cases, they're really, even though it looks like it's for a purpose, it's really for people. So for instance, for the saying of private masses, the beneficiaries would be the people who attend those private masses. So it's almost like a normal private express trust, even though it might fall under non-charitable purpose trust, just because of the difference between a private mass and a public one, which would fall under charitable trusts. Fox hunting, we had one case, quite exceptional. If you look at the case, it's really about education. And education is more something that kind of perhaps falls under charitable. So it's sort of on the boundary there, but okay, in this instance, it fell on the non-charitable side. So I'd say those are not sort of particularly symbolic of this. They're just very exceptional, very much based on the cases that we did. So that leaves us with the fifth one, unincorporated associations. So and one of you had a very good question on this. So unincorporated associations are where, let's say, there's a neighborhood group, and they set up association to, have a playground or something like that, or a sports ground or whatever. So they don't set up as a company, hence they're unincorporated, but they set up as an unincorporated association. Then the question is that a non-charitable purpose trust? So what would be the purpose? The purpose would be sports and recreation, or the purpose would be playground or whatever. The question then is who's going to enforce that? Remember, Morris and Bishop of Durham said you can't have these non-charitable purpose trusts because there's no one to enforce it. For charitable, it would be the Attorney General who enforces it, but who would enforce it here? So again, we're sort of on the boundary. And we had a very interesting case that we looked at in this respect, which was Denley's trust deed. In Denley's trust deed is very similar to McPhail, which we discussed earlier. So McPhail, a trust was set up for the benefit of employees and ex-employees and so on and so forth. But all of these people fell within the is or is not. The distinction between McPhail and Denley is that in Denley, you have the same. You have a trust set up for employees, In fact, I think the group is sort of is more narrow than in McPhail, but it's also for members of the public. So this was for the provision of sports facilities, both for employees as well as for members of the public. So how does that then become a non-charitable purpose trust? Or is it just an express trust, or does it fail as a trust? So it cannot be McPhail. It cannot just be a normal express trust, for the simple reason that you not it fails the is or is not test. It just fails. If 75%, the breakdown was 75% would be employees and 25% would be members of the public. If even if we know who the 75% are, we can draw up a list, or we can do is or is not. We will never ever ever be able to do that for the 25%, because it could be anyone who just comes along and uses the facilities. So it would fail the is or is not test. So it could not be a private express trust under McPhail. But then, could it be a non-charitable purpose trust? And the court said it could. It allowed it to go ahead. And the reason why it allowed it to go ahead was essentially because it argued that in the end, there are human beings who benefit from this. Now, I suppose you could say that about every non-charitable purpose trust, apart from the one, apart from the animals one, where you could say, well, say the private masses, and it was in fact said that even though the non-charitable purpose trust was set up for the purpose of having private masses, in the end, human beings benefit because they're the ones who go there and attend these masses. So you could make the same argument here in the end, and in fact that's what the court did in Denley's Trustee, where the court said in the end, when you go to the sports ground or the playground or whatever, these are real human beings who get the benefit out of that. So the problem then really becomes who sues. So if you're setting up a sports ground or a playground for the whole of the public, just the public, anyone, so you definitely cannot fulfill the is or is not test if it's 100% public, but there's absolutely no one to sue. But at least in Denley's Trustee, you had 75% identifiable people because they had to be employees. So those people could sue. So it's sort of it's sort of on the boundary between a normal express trust and a non-charitable purpose trust, but because of these 25% members of the public, it sort of fell on the side of the non-charitable purpose trust. Let me see if we had another question on that. Ah, yes. So the next question on this is, do charitable and non-charitable purpose trusts satisfy the requirement for constitution for a valid express trust in the absence of beneficiaries? Well, charitable do, because it's charitable, and non-charitable only do for animals and monuments, and the other exceptions would be exceptions precise, or they would be sort of exceptions only in name, because the courts would argue in the end there are beneficiaries, there are people who benefit from this. For charitable trust, the equitable interest vests in the public generally, since this type of trust is for the public. Yes, I think that's true. So the questioner asked if we could say that the equitable interest in a charitable trust has been vested sort of in the public at large. I think that's true. I think you could say that, apart from, of course, the poverty where Dingle and Turner, for instance, where the relief of poverty is meant for employees only or specific sort of groups only. For the non-charitable purpose trusts, where is the equitable interest vested? Well, so I would say the equitable interest in Denley's Trustee is clearly vested with the employees. As far as the members of the public, the 25% is concerned, I don't think you could say that it's sort of vested with them, but I suppose if you could say that there's some discretion on the part of the trustees whether they allow and how many of the members of the public they allow to come and so on. That one's really on the boundary, that kind of case. What about the other ones for non-charitable purpose trusts? Has the equitable interest been vested with, say, with the animals? I don't think you could say that. I think you'd have to say, just like with charitable, it's really vested in the purpose. So when you talk about charitable, the purpose would be, say religious or education, and it would be vested in the public at large. And in the non-charitable, say it would be sort of, could it be vested in the animals? I know it's a tricky one. It's a good question. I I'd say, think of it in terms of charitable, non-charitable. Think of the equitable interest being vested in the purpose. That's probably the easiest way of thinking about it, specifically because unlike the Three Certainties, we don't have a list of beneficiaries that we could say we could use to vest the equitable interest in those people. So kind of maybe just think of it as being vested in the purpose itself. So in other words, for the purpose has to be carried out. Let's see, the next question. No, we have some on secret trust. So let's kind of move on then to secret trust. So secret trust is fairly straightforward. So we have, by the way, one of the past exam questions that I've posted the video online, I think, is about secret trusts. So you can have a look at that as well. So secret trusts are essentially when you set up a trust, but you don't let everyone know about it. So there's fully and half secret. And fully secret trust, always keep it simple. Always imagine fully secret means you write a will. In your will, you leave your house to Uncle George. I leave my house to Uncle George. Full stop. That's it. Okay, no mention of any trust or whatever. Then you go to Uncle George and say, Uncle George, will you be the trustee, and so on and so forth, and then Uncle George agrees. So there's the will part that transfers the legal title, and then there's the trust part, which is kind of done orally on the side. And the point about that, which we already mentioned earlier, for instance, is you're not filling the formalities. You're not filling the formalities of the will, nor are you fulfilling the formalities of creating trust over land, which have to be evidenced in writing. So it's exceptional in that way. The half-secret trusts are a bit different in the sense that the will would say, I leave this house to Uncle George or to George for him to be trustee upon my instructions or as instructed by me, something along those lines. So in half-secret trusts, the people don't know what the instructions are. Only George would know what the instructions are, but at least everyone else would know that there is a trust. Okay, so that's basically the main difference there. The requirements are the same. So the requirements are that in your will you transfer the legal title to whoever the trustee is, and aside from that, on the side, what you do is you intend to create a trust. You communicate that to, say, Uncle George, and Uncle George accepts their role as trustee. So intention, communication, acceptance, and then you have a fully or half secret trust. Why do the courts allow that? Well, we had the fraud theory and the horror of the will theory, but essentially what the court's thinking is, even though this disagrees with, for instance, the formalities, which are normally necessary to establish a trust. So even though we have this conflict, we will allow it because otherwise Uncle George could just keep the house for themselves. So if we're going to say this is not a trust, this is because you didn't do the formalities, well then all we're left with is a will. And if the will only says the house goes to Uncle George, then Uncle George keeps the house. But obviously that's not what you intended. So have a look at that. Have a look at the exam question discussion that I posted online as well. We have a couple of questions on this as well. So one question is, why does a stricter rule apply for half secret trusts and fully secret trusts? So remember, this was the point about if you establish a fully secret trust, you can tell Uncle George at any point in time until you die, and you can change your mind, you can do whatever you want. If you have a half secret trust, you got to tell Uncle George about being a trustee. You got to tell him at the time of making your will, or even before you made your will, not after that. So why is that? Why is there a difference there? Well, I think this is the sort of, we talked about this. You got sort of pluses and minuses on both sides, so a bit of a balance. So fully secret, you got the plus, the positive, that you can change your mind and you can tell Uncle George whenever you want. The negative, the minus on the fully secret side is no one apart from Uncle George knows that there's a trust. So, what if Uncle George decides to keep the house? It's going to be very difficult from an evidentiary point of view to stop that. So you really got to trust Uncle George to sort of do what you told him to. On the half secret side, you don't have that worry, okay? Because you wrote in your will, I leave this house to Uncle George on trust. Okay, you mentioned that word. So you have a bit more security in that way. But with that security comes some, I guess, responsibility, and that would be the negative. So you are required to tell Uncle George, and he has to agree at the time of making your will or before, not later. Next question is, in secret trust, why does the trust fail if the trustee dies? Why can't the testator just appoint a new trustee? and the trust survives. Yes, good, very good point. The reason why is because no one knows about the trust. So if you leave your house to Uncle George and Uncle George dies before the will, before you do, so before the will is triggered, then you can never ever have legal transfer of title to the trustee because the trustee is dead. But that doesn't, I mean, that particular secret trust fails, but you can easily set up another one. So all you do is you revise your will and you just leave it to someone else. You find yourself a new trustee and you leave it to that person, and then that person, you communicate with them as we just discussed, and so you're basically just creating a new secret trust in those circumstances. And we have one last question on this as well, which is something in the worksheets. Okay, so the worksheets say that if a half secret trust, okay, so this is the one where you have to communicate to Uncle George at or before the time of making your will. Okay, so if a half secret trust fails for lack of one of the three elements, the property must be held for the residuary estate. So if the half secret trust fails because there was no intention, because there was no communication, or because there was no acceptance, or perhaps because the communication came after drafting or after executing your will, then what happens? Well, what happens is that the property is held for your residuary estate. So in other words, the trust fails. So if the trust fails, but the will tells you there's a trust, because the will says I leave my house to Uncle George on trust, but the trust part fails, then clearly the house will not go to Uncle George. Clearly the house would go back to the estate, and then it would, because the will would not describe who gets it, it would just be left to the residuary estate to the rules of intestacy. And then it goes on to say that, okay, this does not apply to secret trust, which, yes, that should say, so this, what I just said, does not apply to fully secret trusts where there's such a failure. Because if there's a fully secret trust and there's a failure, then all we are left with is Uncle George, I leave this house to Uncle George, that's it. So because no one knows there's a trust, so then Uncle George gets to keep the property. So the question is, goes on to say, does it mean that under a fully secret trust, the donor's intention can be frustrated by non-acceptance of the original selected trustee? Yes, it can. So if you have a fully secret trust, you have intention, you have communication, but there's no acceptance, then that is true. The trust fails, and then Uncle George would just get to keep the property. So as the testator, just be careful, make sure that you get the acceptance, make sure that that's all done, because if it is not done, if Uncle George does not accept, change your will, okay? You use someone else. If the donor dies before communicating his intention to another trustee, yes, then that's true. So if you haven't found a new trustee, then the whoever is in the will, because remember, in fully secret trust, the will only say this: I leave my house to Uncle George. That's all it will say. That's all we're left with. And if that's all we're left with, then Uncle George gets to keep the house. And yes, is this distinction because of the timing requirement for communication under half secret trust? Yeah, I suppose so. So the for fully secret trusts, you can have the failure, and then Uncle George would keep the property because it's fully secret. Under half secret trust, and this is partly the reason why you have to communicate at or before the time of executing your will. So for half secret trusts, it's that because it's known that there's a trust, if there's a failure of the trust because of non-acceptance or whatever, then everything goes back to the testator or to the testator's estate. All right, very good, and thanks for those questions. Those are very good, very elaborate questions. So mutual wills then, next topic. Mutual wills are basically complementary wills in the sense that two, a husband and a wife or whatever, they draw up the same will. So basically saying the husband says, if I die first, everything goes to my wife and afterwards to the children. And the wife says the exact same thing. She says, if I die first, everything goes to my husband and then the children. Okay, in and of itself, when you have these if you have these complementary wills, you can change them. You haven't committed to anything. But to make them mutual, you need to have the complementary wills, as I just described, plus a promise not to change them. But that promise is contractual. Okay, so you have a contractual agreement between husband and wife on top of the complementary will, I promise not to change it, if you promise not to change it, and the wife and everyone promises, so then we have a contract. So the complementary will plus the contract together creates the mutual will. That's the mutual will. You need both of those. Very importantly for mutual wills, there will be no consequences apart from perhaps breach of contract until someone dies, because the someone dying is called the binding event. So you got to have someone dying. Why do you have to have someone dying? Well, because that creates the trust. Up to the point of someone dying, there is no trust. But let's say the husband dies first. At that point, according to the will that we just kind of made up, where I leave to my wife to be held for the children, at the point of the husband dying, the equitable interest vests with the children. Okay, the wife takes the legal interest, the legal title, but the equitable interest vests with the children. So at that point, the children have acquired that, and that cannot be changed afterwards. They have it already. But before that point, before the husband dies, the children don't have anything. So if there's a breach before, let's say someone changes their will while the two partners are still alive, it's just a contractual breach. But if there's a breach after, so one of the partners changes their will after the first partner died, well, they can do that in respect of their own stuff, their own property. But they cannot do it in respect of whatever has already been vested with the children. So the binding event is extremely important when we talk about mutual wills. So just always bear that in mind if you get a problem question or whatever, and there's the question of whether there's whether the children are entitled to anything. Always make sure you find out if someone has died, because the children are usually not entitled to anything unless someone has died, which would be the binding event. And lastly, we had resulting trusts. So resulting trusts are the trust that can happen basically in two different kinds of circumstances, which was outlined in the Van der Velde case number 2. Don't worry too much about Van der Velde number 2 in terms of the tax law aspects of it or whatever. We're really dealing with the case having established two different types of resulting trusts. So up until 1974, up until Van der Velde number 2, resulting trusts were just kind of this big mishmash. All kinds of things were resulting trusts. All of them had one thing in common, which meant sometimes trust property results back to the donor. But no one had sort of attempted to create categories. And so Van der Velde number 2 created these two categories where it says sometimes the property automatically results back to the owner. And then it's called automatic resulting trust. That happens in two circumstances. Either because the trust fails. So you set up a trust, say like in Milroy and Lord, but it fails because the trust is never fully constituted. Then what happens with the trust property? Well, it results back to the donor or to the testator. The other circumstance where you have an automatic resulting trust is where there's a surplus. The trust comes to an end. Let's say the trust was for education of certain people or whatever. It could be private express education of my children or whatever, or some other very specific thing. Whatever it was for, or compensation of some victims of an accident or whatever it is, once that has been completed, once that is done, if there's any money left over in the pot, if there's any property left, it results back to the donor. Okay, so in both those cases, that's automatic. That's on the one hand. And on the other hand, you have presumed resulting trust. So presumed resulting trust is where we presume the property results back to the original owner, to the donor, to the settlor. So for instance, if you buy Hodgson and Mark, so the old lady transfers her flat to her lodger, but he doesn't pay for it. Okay, there's a presumed resulting trust. So you have transferred your property to someone else, but they haven't paid for it. It's not part of a contract. So it's assumed that even though they have the legal title now, because you transfer the legal title, you hold on to the equitable interest, or to sort of use the word of the terms here, the equitable interest results back to you. Okay, but that's presumed. That's not automatic. The other circumstance where this can happen, apart from the old lady or whatever who transfers their property, is where let's say the old lady buys something in the name of someone else. So let's say you put up the money, you buy an apartment, but you put it in someone else's name. Okay, so they become the legal owner. They have the legal title, but the equitable interest results back to you. That's a presumption. That's presumed. Sometimes that presumption is rebutted, and you just got to learn the circumstances. So for instance, if a father transfers his property, his apartment, to his son or his daughter, then there is no presumed resulting trust. But if a mother does it, there is. So you just got to learn how it works. If a husband transfers his apartment to his wife, the wife gets the legal title, and the husband, nothing results back to the husband. The husband has nothing. If a wife transfers her apartment to the husband, then the husband gets the legal title, but the equitable interest results back to the wife. Okay, so those are the instances where the presumed resulting trust is rebutted. All right, well, that sort of covers the materials that we've covered on the course, and as I mentioned, everything is examinable. We had a few questions, and thanks for those. And I hope you enjoyed this. If you have any other questions, you can email me those questions, and I'll very happily answer. Some of you have for weeks, and that's perfectly fine. Of course, it's very welcomed. Have written sort of practice answers to essay questions or problem questions or whatever. So send those. It makes it easier if you send them in some kind of word processed format, because then I can just go in and make little notes and comments and send it back to you, and hopefully that will be helpful to you too. So you still got a few weeks to go in terms of preparing, and good luck with that. And I'm still here, so you can always ask questions and let me know, and I'll try my best to answer any questions you have. All right. So anyway, for now, thanks very much, and have a good rest of the day.